members. We have the quorum. It's time to start. This is the Bills Committee on Pesticides Amendment Bill 2013. Election of Chairman. Rules of Procedure 4. I'd like to invite nomination. We need to have one member making the verbal nomination, and we need to have a seconder, subject to agreement of the member nominated. Do you want to be nominated? No. Mr. Chung-kai. Mr. Albert Ho nominated Mr. Chung-kai. Seconder. Albert Chen, second. Mr. Sin, you accept the nomination. Do I hear any nomination? If there are no other nominations, Mr. Chung-kai is elected ipso facto.
Okay, 好，各位同事，大家
Members, do you see the need for a vice chairman? If not, then let's invite the administration in, please. There is a PowerPoint presentation by the administration. The PowerPoints are being distributed at the moment. First of all, I invite the administration to present the bill to us.
我相信大家睇過座位。
From the seating plan, I gather members are aware of all the officials, so I won't introduce them one by one. Let's invite Mr. Philip Chan, Deputy Secretary for Food and Health, for a presentation of the bill in brief. Chairman, thank you. Thanks very much, members. If I may take a bit of time to brief members on the Pesticides Amendment Bill 2013. The purpose of the bill is to amend the Pesticides Ordinance, Cap 133, to make us comply with the Stockholm Convention and Rotterdam Convention regarding the requirements on pesticides. The bill seeks to protect human health and the environment. On the 12th of July 2011, the administration consulted the FSH panel of the Council. Members expressed support for the bill. Subsequently, the administration consulted various organizations, the licensees, the pest control organizations, the laboratories, the farmers, chambers, and environmental groups. They all support this particular bill. The administration would like to take this opportunity to update the relevant provisions, not in a large scale. As I said a moment ago, the purpose of these conventions, the Stockholm Convention, is to regulate the persistent hazardous materials, in particular pesticides, in order to eliminate them. The Rotterdam Convention is to regulate the trade regarding the hazardous chemicals. The CPG has in 2014 and 2008 applied the conventions to Hong Kong respectively. So in order to fulfill all the obligations, we have to amend the pesticides ordinance. Obviously, regarding hazardous chemicals, we do have another piece of ordinance that was enacted by the Legislative Council in 2008, and that is Cap 595 regarding non-pesticide. hazardous chemicals. And this bill is about pesticides. Under the existing ordinance, i.e. under the Pesticides Ordinance, we do have a registration system. For the importation, manufacture, sale, possession, and supply of hazardous chemicals, which are pesticides, we do have a licensing system. In 2007, the administration proposed the amendment of the legislation, and we consulted the members of the public. And that's by way of a background as to what we have done. Other than the amendment relating to the conventions, we proposed that a registration system be brought in, and also a regulatory system for the applicator of pesticides. During the consultation period, it was found that if we were to introduce a product registration system and a scheme to regulate applicators of pesticides, in other words, if for those who are applying the pesticides for pest control purposes, if these proposals were to be adopted, then our view is that some small pest control companies might be driven out of business due to high operational costs. And there may be pesticide applicators who might fail to be registered because of the onerous training requirement. So after consultation, we've decided to drop these proposals. But it's not the case that we haven't done anything at all. As a matter of fact, we spent quite a bit of time and devoted much effort to the upgrading of the training for the applicators, and develop codes of practice, and also enhance understanding of pesticides, and so on. So after dropping these proposals, we still are of the view that in the interest of public health and in the interest of safe use of pesticides, we have to do something. So through the enhanced training and development of codes of practice, and also the enhancement of public awareness and understanding, we hope that through these various areas we can achieve the objective. As I said on 12th of July 2011, at the FSCH panel, we briefed members on the background. And let's come back to the bill, the amendment bill in front of members. This is rather straightforward. Basically, we have to comply with the requirements of the two conventions. The panel supported this direction. Also, we mounted another round of consultation on the stakeholders on the 6th of February 2013. We introduced the bill to the Council, and that's by way of a background. Let me go on to the regulation. Under Cap 133, a person importing, manufacturing, selling, supplying, and in possession and using pesticides that will be subject to control. And the DAFC has to keep a register of the pesticides. So all these pesticides imported and manufactured and possessed by anybody will be subject to a license issued by the director of AFCD. So they are in the register, and if you want to import these registered pesticides, you have to seek a license from the DAFC. There are some unregistered pesticides. The DAFC will have regard to the international standards and can consider whether these pesticides have to be registered. Now, if someone were to import or sell unregistered pesticides, that they will have to obtain a permit from the DAFC. Now, that would be more stringent because of the high toxicity. Under Cap 60, import and export ordinance, other than those in transit or air cargo transshipment, one will need to have an import and export license. Under 133, one has to get a license for import. Now, for unregistered pesticides, one will need to have a permit subject to more stringent requirements. And under 60, one has to obtain an import and export license. So we're talking about a dual-track control. Now, for the pesticides governed by the conventions, they are unregistered and they are subject to the permit requirements. Now, you may say that we are now legislating to bring us in line with the convention requirements, but please bear in mind that these pesticides are unregistered pesticides and they are subject to control. Cap 133 cannot comply with the conventions regarding the use and export of pesticides. In order to bring ourselves in line with the conventions, our legal advice suggests that we have to amend the ordinance to make sure that these pesticides it will be subject to the DAFC regulation. Let me move on to the amendments relating to the conventions, and that's the core part of the bill. We will put the pesticides governed by the convention in the schedules. We call them scheduled pesticides. The SFH can, by notice in the Gazette, amend the schedules. The schedules would govern the import, manufacture, sale, supply, and possession of the scheduled pesticides, and they will be subject to a permit by the DAFC. And under the ordinance, there is the inspection and investigation power vested with the DAFC. Also, the two conventions do not apply to laboratory tests and also chemicals that do not affect human health or the environment. Now, if we're talking about this area, let's say laboratory research or chemical analysis or reference standard, they do need a reference standard in chemical analysis. If they are for these purposes and that they are in quantities not likely to affect human health, then the convention will not apply. In order to live up to the spirit of the two conventions and also to facilitate laboratory research, we make it clear in the bill that a person importing, manufacturing, selling, supplying, and possession of any scheduled pesticides not exceeding a certain quantity, i.e. 10 gram or 10 ml, that is contained in an individual package or container and is used or intended to be used indoors for laboratory research, chemical analysis, or as a reference standard, they would be exempted from the permit requirement. So this is in line with the spirit of the two conventions. So we do not restrict this to the spirit of to what is required under the spirit of the convention. We are applying the same standard to all pesticides in this category. We consider the quantities and this threshold will not cause any harm to human health and the environment, and that's in line with the conventions. As regards import and export, they will still be subject to import or export licenses under the INEO in this regard. And these are convention pesticides, and they are of higher toxicity. So we should keep a record of these pesticides for audit trail.
Proposal is also made that all the registered pesticides not regulated by government regulation, should they comply with the above criteria, they will be exempted from the amendment. So what I just mentioned was the requirements for compliance with the conventions. Apart from amendments related to the conventions, we are also making use of the opportunity to update CAP 133, which was which dated back to 1973. So we need to do the updating. Firstly, we have stipulated that based on the decisions on appeals made by the director of AFCD, we think that we should propose that appeals should be made to a special committee instead of the chief executive, as the case now. I think that's the spirit of many ordinance now. That is, the request should be made to the AAB instead. AAB is a non-official independent body, so I think it's better to have an independent body to deal with appeals. And secondly, under CAP 133, we actually authorized certain officers to enter premises without a search warrant. And they can carry out routine inspections. So we are going to limit the powers of these officers. That is, under the applications for licenses for any premises whose address are provided in the license. In other words, when someone applies for a license, if that person has written down his address as the premises where operations take place, sometimes this could be a residential flat. Even if it's a non-residential flat, we consider about the residential nature of a flat just to ensure privacy. But if someone has written in the license that the residential address is the premises for the business, then the authorized officers would be entitled to enter the premises without a search warrant. This is to ensure that officers can enter premises quickly when there's a need. But if the address is not provided in the license, then the officers cannot enter the premises. And thirdly, we are going to remove some inconvenience to the sector by removing another restriction, particularly some vertical lines on the container. So often this ripping requirement can be found on pesticide containers. But this is an outdated requirement. In order to remove the burden of the trade, we are making exemption to this ripping requirement. As I said, we have done a lot of consultation before proposing the amendment bill. I'm very pleased to see that during the consultation period, we've got the support of relevant groups. Under the existing ordinance, the provisions are not relevant to the government, but we have looked into whether the amended provisions should be applicable to the government. We feel that regulations of government departments should be carried out on the same basis as private companies. Therefore, we propose that with the amendments, the amended provisions should be relevant to the government, but we think that we should exempt the government and public officers from criminal responsibilities or liabilities. We need to make sure that relevant people comply with the law, and people who are actually carrying out their responsibilities for the government should be exempted from criminal sanctions. In other words, the government remains the body bearing ultimate responsibility. We need to ensure public safety and the environment. So we need to ensure that Hong Kong complies with all the requirements, and we hope that members would support the amendment bill as soon as possible. Once the amendment bill is approved by LegCo, it will take effect 6 months after Gazetto. That is after third reading. Following the Gazetto, 6 months later, the law will take effect. We want to give the sector 6 months to get used to the new regulations. So, Chairman, that's all for my briefing. I hope that it helped members understand more about the amendments. So I'd like to ask members with questions to go ahead. Albert Chen, then Chang Yuyan. Chairman, as for the issue of pesticides, I've been following up on it for many years. In the past, with AFCD and other departments, we've had a lot of correspondence. In November 2011, I raised the question in LegCo. My understanding is that the amendment currently involves 2 international conventions, but the paper hasn't really explained in detail the problems facing pesticides in Hong Kong, or the level of public dissatisfaction with regulations now, and also the amendments now. What loopholes are we trying to plug with the amendments? Why is it that there is still a large number of pesticides still being in use now, affecting the health of children? There's no mention of how the situation will be improved with the amendments. For example, when I complain about a certain mushroom, which could be hazardous, it's not included in your paper. So it seems that there is still lack of regulations on some hazardous products because they do not come under the category of regulated chemicals or pesticides covered by the ordinance or the conventions. I think next time at our next meeting, I hope that the government can explain clearly of the pesticides in use in Hong Kong. What are they? And with the amendments, which ones will be regulated and which will not be? The convention dates back to 2004. So now you're waking up to the reality. I don't know what made you decide to go ahead with the change. But after the amendments are approved, what residual problems of pesticides will remain unresolved? We need to know, because most members of the public do not quite understand, neither are they concerned about the implications of the law. What will be under control under the amendments? What will be the effect? And for products that are not regulated, what are you going to do with them? So you need to give them more explanations on that. Director, thank you. Mr. Chen, under Cap 133 of the Pesticides Ordinance now, there are provisions regulating the import, manufacture, sale, and supply of pesticides. The objective is to ensure safe use of pesticides and to ensure public safety. So we hope that the regulations can protect public health. We understand that some pesticides may cause damage to people's health. As I said, under Cap 133, Section 4, the Director of AFCD has the register, which has 2 parts. The register itself allows the department to register pesticides with low or a very low level of poison. And there's also restrictions on the level of concentration of hazardous materials in the pesticides. And there are also a category of unregistered pesticides that cannot be registered. No, Director, well, I'm going to talk about the particular kind of mushroom, Albert Chen mushroom, later. For non-registered pesticides, as I said, they can be imported but they need to obtain a permit from the director of AFCD. It's a permit, not a license. If you have a permit, then the director will attach conditions to it because of its high level of poison. And there's a chance that the permit would not be issued. So that's the existing system intended to have stringent regulations over pesticides. I understand Mr. Chan's concern. I know that you have checked the schedules, and yes, as you pointed out, the particular kind of mushroom you mentioned is a registered pesticide currently. So it's not covered by the two conventions because it's already on our register. I know Mr. Chen is most concerned that this is a poisonous product. But all registered pesticides in Hong Kong need to comply with the labeling requirements and are safe for use. When the director of AFCD approves the registering of the mushrooms, it has regulations on the concentration level. And the paraquat, the mushroom paraquat, needs to be diluted when they are in use in Hong Kong. And we also require that the paraquat need to be added with some kind of flavor so that people will throw it up once they've swallowed it. So these are kinds of protections put in place, to ensure safety. The AFCD is now studying fading out the registration of paraquat in order to ensure that paraquat can be used to wipe out pests. In fact, paraquat is used by many to wipe out pests. But why do we want to fade it out? To make it a non-registered pesticide, we need to have time and we need to plan about what to do with that. My point is, yes, paraquat may only be the tip of the iceberg. The issue is there are a number of reports that show that paraquat is actually hazardous to the health of people with respiratory problems, children particularly. And in many places, as pointed out by the Secretary, is widely used and even is used in places near nurseries or kindergartens in villages. And also households in villages use. I need to declare my interest. I live in the rural area. When spring comes, you always can feel and see that a lot of the pesticides and the product is used to kill pests near village schools or in many areas in the countryside. People can feel it, and then children are actually exposed to the risk. And yet there's no control, and there's nothing you can do to control the use of this pesticide. You just let people use it, as much as they want, and the government is allowing the poison to continue to harm the health of our children. I was very expectant, thinking that, with the amendments, situation can be improved. But now you're telling me that apart from products that comply with the international conventions, the most widely used pesticides in Hong Kong would not be covered by the amendments. And you said you're going to take action later, but of course I understand that you want to comply with the requirements of the conventions. But still, since you said that the AFCD is concerned with the problem, why can't you incorporate these poisonous products into the amendments to put them under control? Chairman, I think the director under existing law has the power already to, upon the basis of a review, looking at the level of poison and so forth, the director under existing law already has the power to remove a pesticide from the register. So that's why we are not including them in the amendments. As I said, the director also has a plan to remove paraquat from the register, but it needs time for consultation because it's such a pesticide that's such widely used.
Well, what about the timetable? How soon can this be done in response to Mr. Chen? Chairman, you said that farmers are using them. Now that's one level. I'm talking about those who are not farmers themselves. There are many villages who would purchase a bucket of paraquat and spray it all over the place, and this is quite a commonplace in the new territories. And this is not for agricultural purposes. And like you said, they use it for exterminating mosquitoes. The South China Morning Post did have some expose about this. Oriental Daily did have some articles on this. The toxicity is pretty harmful. The government will not deny that there is toxic properties, and all people, children, may be affected adversely. Now, this has been confirmed. I've been written to the administration so many times. I raised the question again in 2011, and 2 years on, why is it that we cannot speed up the regulation in this regard? I'm beseeching the administration to stop the indiscriminate use of these kind of toxic substance. Well, farmers are using it on the farm and also on the roadside, near the nurseries and kindergartens. They're spraying this all over the place, even in mid-levels. Near the high-end luxurious properties, they're spraying this all over the place. Permanent Secretary, there is a registration system. The director would like to take this off the list. Would this be banned from export? Chairman, if they don't have a license, they cannot import this into Hong Kong. Well, when they seek a license, the director can choose not to grant the permission. Perhaps the director might wish to add. On Mr. Chen's concerns, in recent years, we have reviewed this kind of pesticide. Our conclusion is that the paraquat available in the market, in terms of concentration, and also coupled with all the preventative measures, would present a pretty low risk. Of course, we are concerned about the widespread use of this substance. After our study, we do have the plan to phase it out. We're going to remove this from the registered list. Mr. Chen has got a point there. Other than some nurseries or some horticultural companies, farmers are also using paraquat quite often. If we remove this all of a sudden, it would have extensive implication. So we have to make sure that those who are using this substance, paraquat, the farmers, the horticulturists, we'd like to minimize the impact on them. We're looking at whether there is an alternative to minimize the impact. Also, they do have some a stock of the paraquat, and we do have the plan to remove this from the registered list. But we are going to be liaising with the trade about the whole timetable regarding the removal. Now, you asked me about the timetable. We haven't quite found out about the difficulties from the trade. We haven't quite reached any consensus, so we don't have a timetable. Although we do have the plan to remove paraquat from the list. Well, on the same issue, Now, since this is toxic, why is it that the two conventions do not include it? Chairman. Now, it's not the case that anything which is toxic will be included into the conventions. The two conventions are for special purposes. Now, for the Rotterdam Convention, there are 43 different substances, 32 of which are pesticides. Some of them are highly hazardous. Stockholm Convention 22, 15 are pesticides, and 7 are chemicals. And they are of high toxicity, like the POP, which is constituting long-term harm to the environment. Paraquat is not classified in this category, and this is already a registered pesticide in itself. Tommy Chung and Mr. Ho. Chairman, a couple of things. The administration has been consulting for so long. I think we might set aside some time for the deputations because we're not really pushed for time. All right, this will be dealt with in a moment. In 2004, 2008, you said that China rectified these two conventions. Are they being implemented? Yes, they have. How long have they been implemented? China ratified a lot of conventions, but they do not implement them straight away, like the smoking ban, for instance. Now, have they started implementing these conventions? Mr. Lau? Chairman. For the Stockholm Convention, China is the founding member. They've already started implementing the convention. Third, I'm really worked up about it. I hope that other parties would support this as well. Now, for officials, they would normally be left out of it. Now, this ordinance will be applied to the government, although the officials will not have any criminal liability. Now, who will be going to prison if something were to go wrong? Will it be this chief executive who will be going to prison for that, or who will be going to prison? The SMEs, if they use it wrong, they will be imprisoned, but government officials will be getting away with it scot-free without any criminal liability. Over the years, whenever I see this, I get the feeling that the government officials are really above the law. And if the government doesn't amend this, I will be amending this exemption granted to government officials. All right, let's deal with the deputation later on. I think the second part is merely a comment. Will you respond to that, administration? Chairman, when we consider the applicability of this ordinance to the administration, we did consider the consistency factor. Government departments, like private operators, should be subject to the same level of control or regulation to ensure public safety. As part of the government, we have to comply with the ordinance. So this ordinance is going to be applicable to the SAR government. As to public officers, I think they should be exempted from any criminal liability in the course of discharging their duty. But we do have administrative measures to make sure that public officers comply with the legislative requirements. I mentioned the hazardous chemicals control ordinance. Now, with regard to that ordinance, I kept 595. That is also to implement the control of hazardous chemicals under the convention. As I said a moment ago, the same applies to the same treatment will be given to public officers in the same way. Mr. Chung, will the government has always been consistent since the colonial government. The government officials are above the law. I think this is time for us to discard this old practice. If you allow you to get away with it, next time you will be saying that you're making this consistent. Now, for the SMEs, the bosses will be held liable, but public officers will be exempted in discharging their duties. I'm wondering why they should be exempted. And this is wholly unfair. And I hope that you would go away and consider this. This consistency argument is really too used too indiscriminately. The same can be said about smoking. CGO public officers puffing away at CGO who should be held liable. There is no criminal liability there. How can that be? Well, I support you in what you said regarding smoking. Well, they advanced this consistency argument. I mean, they started this consistency argument before we were born, and they're already above the law. Right, Mr. Ho? Chairman, thank you. I've got a similar question here. I don't quite understand the logic. You have effective measures to make sure that they comply with the law, but what if the penalty is extended to public officers? You have nothing to fear, do you? Now, government officials will not be prosecuted for any behavior. Do you mean criminally prosecuted? I mean, what about civil liability? Do they have any civil liability? Now, I won't ask any further question about the government officials being above the law. Now, let me come back to Para 7 of the brief. The Director of Egg and Fish can have the power of investigation and inspection to enforce the law. And Para 3 also says that the EPD in 2007 enacted the Hazardous Chemicals Control Ordinance, which went into effect in 2008. Now, this Hazardous Chemicals Control Ordinance, does it have any power of inspection and investigation vested in public officers? From your presentation, I heard that anybody importing, manufacturing, selling, and so on, all these scheduled pesticides, and if they are contained in an individual package and not exceeding a certain quantity and is used indoors for laboratory research, chemical analysis, and as a reference standard, they would be exempted from the permit requirement. Now, I'd like the administration to tell us, if they are exempted, how can you make sure that they will comply with the relevant requirements, and who will be allowed to make this application? Will the restriction, or will the application be restricted to certain categories of people? And you also mentioned the ribbing requirement for the visually impaired people, and they would know from touching it whether certain items are of toxic or contain toxic substances. And with this removed, would you ensure that the visually impaired people would be able to distinguish them?
Firstly, about the issue of public officers, I'd like to point out that the public officers be mentioned under Section 3A2, the SAR public officers and officers in the course of duty will not be liable for any offense. For people acting as in the course of action, they are actually entitled to the protection, that is immunity from prosecution. If, in other words, if it's a public officer but whose but in fact is dealing with this pesticides in his personal capacity, then that's against the law. As for civil liabilities, as I explained earlier, under the law, under Section 19B of the ordinance, for public officers who, in exercising his authority or because of various factors, like in English, that is, he personally, on the conditions that he's doing it in good faith, and he's using his power in accordance with the law, or his motivation is exercise his power in accordance with the law, or his in accordance with the law carries out his duty. Any criminal liabilities arising from that, he would not be held responsible. But still, the government would be held responsible. In other words, it wouldn't be that because that person is not liable for civil liabilities, then nobody will be held accountable. The government will still be held accountable. Anyone who's acting in compliance with the provisions in the law would not be liable for civil liabilities. And your fourth question is about ripping, the ripping requirement. Well, for civil liabilities, in other words, the government will be held accountable in the end if the officer is not. Yes. The government, would need to be accountable, bear the legal responsibility for that particular course of action or not taking a certain course of action. We're talking about civil liabilities here. Yes, he was asking about this issue of civil liabilities. Yes. And your other questions about the power of inspection and the ripping requirement. As I explained earlier, in the past, there was a need for the requirement because we wanted to help, say, the blind who need to touch it and feel it. But now, a lot of the containers already have such ribbing. So, therefore, you can't really tell by touching the surface already. So, I don't quite understand. Can you explain to me what ribbing means? Ribbing means that on the container there is some uneven surface. So the uneven surface would cause the people touching the container to know. That is to feel the difference from other containers. So some old-style containers but nowadays, actually, if you look at a lot of the household products, you will find similar design. So you can really tell by just the ribbing. There is such a regulation under current law requiring the sector to comply with the ribbing requirement, but I don't think it serves any purpose nowadays. And the sector has also requested that we change the law, and we've reviewed the situation, and we found that there's really a need. Have you asked the blind people? I think the ribbing requirement was intended not just for the purpose of the blind. It was only meant to make sure that for any glass containers, that people can feel the difference on the surface. That was in line with international standard. But the situation has changed now. It wasn't really meant for the purpose of the blind alone. Therefore, with this time, with the amendment, we didn't ask blind people about their views. In many household products available in supermarkets, household products that could be hazardous, you won't find the same design on their containers either. You can't just rely on the feel of a package or container to tell the difference nowadays. Okay, how about this issue of inspection power? Yes, that the inspection power will remain. Can you give us more details? Yes, in inspection and investigation powers. Inspection and investigation powers, what do they include? Under existing law? Yes, may I ask the director to supplement? Yes, I think in our routine inspections, we'll check the pesticides stored in the premises, whether they're registered or whether they have been given a permit. So that's the purpose of inspection. Any other questions? If not, Albert Chan, I'd like to be given a paper by the government to give more details on the situation in Hong Kong and what improvements will be made by the amendments. We need to know what difference do the amendments make? Or is it just a routine amendment to ensure compliance with the conventions? Yes, I think in the PowerPoint you said that there is this rule for register and giving a permit. But do you have any figure on the annual figures of imports and so forth? So as suggested by Mr. Chen, can you give us a paper? Since you've got the figures available, can you work out over the past 2 years what have you allowed to be imported and what pesticides are still being used? Well, I only know about paraquat, but besides that, what other pesticides are exempted from the provisions and what you're going to do with them? Because if there's a new kind of pesticide that comes up and that's hazardous and yet is not covered by the law, you know, there's so many different kinds of products available on the mainland. Okay, so please give us a paper listing all the pesticides regulated under the Stockholm Convention, and beyond these two conventions, what have you allowed for in Hong Kong, those that are registered or given permits in Hong Kong? And so you have to list out to us what are being under regulation that are not covered by the two conventions. And we'd like to know the figures. Yes, Chairman will definitely work it out. For products not covered by the conventions, in fact, they are under regulation. They're regulated in Hong Kong. It's not that we are not regulating pesticides beyond those covered by the two conventions. That's not the case. And Albert Chan mentioned that pesticides of paraquat. So please list out other similar products in your paper. Next one is LNL. I echo the view of other members just then about liabilities. If you look at the bill, Section 17, on who have to bear the liability, legal liabilities, that is those who violated Section 7 and 8, and they're liable for fines at level 5. Before it used to be 50,000, now it will be a high level and lead to maximum imprisonment of 1 year. I think the relevant criminal behavior. In fact, there is a possibility that there could be a civil servant engaged in the behavior mentioned in Section 8. Section 8, subject to Part 2 of Schedule 2, except under and in accordance with the permit, a person must not import into or cost to be imported into Hong Kong and so forth. Well, say a government department may place an order through a person, a staff, for imports that are scheduled. So as Mr. Jones said, what this person does is similar to what staff at a small enterprise, small-sized enterprise does. So I think the government should maybe, at this Bills Committee later on explain more why the person is only subject to civil and not criminal liability. And also the proposed amendments would revoke the Sections 15 bracket 3 and replace it with a new one. The original Section 15 bracket 3, why is it to be replaced by 15A, big letter A? What's the rationale behind? Chairman, as for Section 15 is, well, because this ordinance dates back to 1977, and you can see that when the law was drafted, the public officers mentioned were allowed to enter premises without search warrant to get samples. And we've actually taken into consideration protection of personal premises. Therefore, we've limited the powers of the officer and come up with 15A, Section 15A, which states that the conditions under which the person can enter premises without a search warrant. That is when the address is filled in the application for license, and that address is a residential flat. So that is also a correspondence address. So we've actually limited, attached some conditions there. 15 bracket 3, the original 15 bracket 3, there is a time limit, 9 to sometime in the evening. So is it that the definition of premises is changed from any premises to a certain kind of premises, but in your original wording there is this 9 to 6 time limit, and yet that time limit is gone now. Why is that? Yeah, 9 to 6 is in the existing law, but if we were to inspect a premises, and if we do have doubts, have reasonable doubts that there are unregistered pesticides, hazardous pesticides in the premises, then the officers can enter the premises anytime, not necessarily within the time limit. So in place of 9 to 6, we use the wording any reasonable time. I'd like to ask again, you said that in the original 15 bracket 3, you may be worried. You might be worried that it's giving the administration too much powers. Any person's homes is precious. So if you are thinking that way, then why don't you require the possession of a search warrant?
Chairman, there is an actual need when the frontline staff is enforcing the law. There may be some premises that have toxic pesticides. By the time you get the warrant, they may have been removed. Well, this is not the reason. I mean, for more urgent matters, you do need a warrant. It's just that this is handed or inherited from past practices. I mean, for even urgent cases, some urgent cases do need a warrant. Other than urgency, to have any other reasons. Chairman, we do have the practical needs. Perhaps my colleague can fill members in on the requirement in the light of experience. There are some licensees who make the application using their home address as the registered address. And these are mostly in the new territories. So they have the shop in front and they have the residential dwelling at the back. And this is the registered address. Now, in some other cases, they are engaged in trading of pesticides. They don't have an office. Their office is actually the home. And they registered their office address as their home. In our routine inspection that we do conduct inspection on a regular basis, during the inspection we have to enter their premises, the registered address for the inspection. It just happens that these are residential premises. Now we cannot enter by force. Now let's say this is a residential dwelling. We can go in, but if they refused our entry, then we will get a warrant. If we suspect any problems, we normally would seek a warrant. But if we don't have any suspicion, it's just that they have registered their residential address as the license address. Then there is no reason why we cannot carry out the inspection at these addresses. Now we changed from 9 to 5 to a reasonable time. Now let's say we enter the premises at 4. You cannot really make the public officers leave by the time by the time it is 5 p.m. Of course, we will not barge in at the crack of dawn or 6 in the morning or something. So we specify reasonable time. Chairman, I heard what you said in explanation. I will consider this myself. But from what you said, you cannot enter by force. If they refuse entry, you cannot break down the door. Where does it say in the ordinance? Now, from the text here, you cannot enter without any warrant. In future, now the law says that you can enter without a warrant, and you may force your way in. You must realize that a court warrant is there to make sure that this idea that someone's home is their castle will be respected. Now, where in the law does it say that the law enforcement officers cannot enter the premises by force? Chairman, as far as I understand, if force has to be used, then the law would say that minimum force would be necessary, and there is no such wording in the law there. Or I understand 15.1 is for the application of a warrant. So if you compare that with 15A, the warrantless entry, if you juxtapose the two, then you can tell the difference. Right, I understand your logic then. Thank you. Thank you so much, Chairman. Zhen Zhuhou. I'd like to dwell on the details. 9.3 for scheduled pesticides or unregistered pesticides, if they are generated in the course of manufacturing, this will not be against the law. What do you mean by that? If you mix two substances, and you generate this kind of pesticide, then you will not be against the law. And also transfer, removal. Let's say I put this at a certain place for 2 years before removing it. What is the sector's view about it? Well, through the chair, what clause are you referring to? I have to ascertain what clause we are talking about. Clause 3.9, adding to the blue bill, clause number 3. Beg your pardon. Clause 3.9, bracket 9, add number 2, 3. So where in the marked up copy? Where is it in the marked up copy? All right, let's stick to the marked up copy to make it consistent. 0002, the Chinese version. There is a star there. Are we on the same page? 0002 in the marked up copy. On the right hand side there is a star there. Chairman, I think this is for clarification and to remove doubts. We are making this clear. I'm not sure what Mr. Ho's question is. Is it his concern that this will give rise to certain problems? Well, I'm not a chemistry person, so I don't quite understand that. Let's say you have 1 liter of substance mixed in with another liter of substance. Will it cause any problems? Right, so it's not a legal matter, it is a chemical question. Mr. Lau, please. Now, in the course of manufacturing certain chemicals, it's not the case that A would give rise to B. Now you have to go through A, B, and C, and D before you manufacture E. So they have so many tubes and things connected together. Now, for the manufacture of fertilizers or films or the aircraft oil and so on, in the process they would generate a certain substance, and these may be regulated by the conventions. If you take this out and you put it into a bottle and use it as pesticide, that would be okay, but the manufacturing process may not be exhausted. If they want to manufacture a substance called D or E, there may be substances generated in the process, and we do not regard that as pesticide, because the ultimate objective is not to manufacture that kind of pesticide, but in the process of manufacturing they produce that in in the process of manufacture a particular chemical. All right, what about transfer? Through the chair, can the question be repeated? 3, 9. For transfer and removal, now let's say they are on the same mode of transport, and there will not be any or transshipment. Would there be any time limit? Chairman, there is no time limit in terms of transshipment. The idea of transshipment is that in the course of transshipment, these substances are not in the Hong Kong market, so they would be exempted. Of course, they would be subject to certain conditions. They have to be on the same vessel. For instance, if you're talking about 4B1, they have to be in the same vehicles, vessels or aircraft if they are on the same mode of transport without entering into our market. But here it says transfer to another mode of transport, 4B. Number 4, the exemption is that let's say you are importing into the mainland via Hong Kong without entering into the Hong Kong market. Right, that's the idea, Chairman. Mr. Albert Chan. In 2006, when I was in LegCo, I did raise some questions regarding the pesticides. If you refer to my Q&A in the year 2006, you might wish to have a look at these pesticides that I mentioned and see how much you can control them. The names may not reflect the concentration of the substances, and they may be misleading. Also, Chairman, in dealing with these pesticides, normally you have 2 levels. You have the convention, which govern the pesticides at the national level, but in overseas jurisdictions at different cities, that the conventions are represent the policies of the central government. They have the acts and legislation governing the use of pesticides, but in different cities they have their own bylaws. Let's say you have the federal government and the central government electing the law governing the use of these pesticides. But as far as I know, in Canada, some of the cities would ban the use of pesticides wholesale, and they have the city bylaws. They are invoking the powers under their own jurisdiction to ban the pesticides as a whole because of the residential dwellings and so on. These pesticides are used for farming purposes and for commercial purposes, but in the city settings, because of public health, they would ban them. So in overseas jurisdictions, they have 2 levels of control, and they're more stringent. There will be no sale of the pesticides. Maybe City A would allow that. The neighboring city would ban the pesticides altogether. So it all depends on the attitude on the part of the city authorities. Now, with regard to these control, you're talking about the farming and industrial use. Now, what about the residential dwellings? A piece of lawn, a small piece of lawn, for instance, with some weed. And it's not just rural areas. In central, in mid-levels, people are using pesticides as weed killers. There was a complaint about a kindergarten in mid-levels. So for some reason, these kind of herbicides were used, and despite the complaints and nothing was done about it, it wasn't the responsibility of the Education Bureau nor the AFCD. The parents are very concerned about the kids' health. Now, my question is, in overseas jurisdictions, they have 2 levels of control, but in Hong Kong, we only have these ordinances. Of course, we can regulate the use, but as far as the city administration, shouldn't there be more stringent control? Can this be done under the law?
Secretary? Yes. Safe use of pesticides is the ultimate objective of the ordinance. I think we share the same goal with Mr. Chan. Yes, for example, in the residential area, Hong Kong talks about zonglings and not. For example, in Newtown, pesticides should be banned. And you may use pesticides in farmlands, but can you come up with more stringent criteria? That is, pesticides be banned for the entire urban area? Well, Hong Kong is a city. Well, I'm talking about zoning. For example, residential area, new towns. Can we ban pesticides there? That makes things simpler. Because it would not have any effect on the farming industry. It's very cumbersome to introduce, restrictions alone, because parents are worried about the health of children and elderly people. I really have doubts about whether your latest regulations would be effective. And there's no need for pesticides in urban areas. If there are just some wild grass near where I live, then people who are too lazy to remove the grass just use pesticides. But in fact, it doesn't really take much effort to kill wild grass. Okay, I'll say a few words and I'll ask the chairman to supplement. Hong Kong is a highly congested city. In some areas, there's a need for pesticides, for example, to kill mosquitoes. So there may be a need for some people to use pesticides. So if we ban it altogether, then it could cause inconvenience to some. I think our existing system is that apart from having the registration, licensing system, and the issuance of permits, we also need to take note of the practical issues. That's why we have laid down with the sector number of favorable manual for use of pesticides. Well, yes, my understanding is pesticides are banned in Vancouver. The only in the Vancouver does not allow the use of pesticides. Director, well, let me stress that under the existing system, through the registration system, we will only register pesticides who are moderately hazardous or have a very low level of hazardous. And there's also constraints on the level of concentration. For the more hazardous pesticides, we will not register them. We only issue them with permits attached with certain regulations so that their use can be controlled if they are really needed for some purposes. For some pesticides still in use now in urban areas, well, people have said that, people who object to the use of pesticides just object to them, no matter where they're safe or not. There are also parents, we understand, who are concerned about the safe use of pesticides near schools. Each time we received a report or case, we would look into each case and find out about the risks to public health of those pesticides in question and see whether there's a need to attach more regulations to it or even remove them from use. Paraquat is one example I mentioned. We understand that there are members of the public who are very concerned about the use of pesticides in particularly highly congested area. But we will continue to, through the current system, review the use of pesticides in Hong Kong and make relevant adjustments. Well, ever chance that Vancouver bans the use of pesticides altogether. So since you are going to write us a new paper, can you explain to us the new system, yes, under which we have permits and licenses issued? But how about the situation in Vancouver and other cities? Can you compare the various systems as well in your paper? I know you may have adopted the system for many years, but now that there may be other new systems in other places. Mr. Chen, is he referring to paraquat? No, he's talking about the case of Vancouver. Where in Vancouver all pesticides are banned. But I think you need to look at the concrete situation, how things are done in Vancouver. You can come up with a comparison. Maybe Albert Chen, I don't know, maybe Vancouver only bans the use of some strong pesticides only. So please do a comparison and let us know. Just then, Mr. Chung Yu-yan, I think, formally asked that we should consider deputations. Any members object to that? No? Even though the government has carried out consultation, I think on the whole, we can do several things. One, on our website, we can issue a circular inviting those interested to come to express their views, and also to invite the organizations consulted by the government, including 5. The organizations including the Hong Kong Pesticides Professionals Association, Hong Kong Pesticides Association, and the South China Association, and other organizations consulted by the government. There are a few of them altogether. Yeah, I think we can invite them on our website. Should we accept written submissions or give the organizations a chance to come here? Let us set a date. There are only 3 time slots in March. 14th, 15th. March 14th, 15th in the morning or in the afternoon, the 14th. Morning on the 15th. Or the 19th. Morning on the 19th. Chung Yu-yan and Helena Wong. How about the morning of the 15th? I have a Hong Kong TB board meeting. Are you okay in the morning of the 15th? 8:30? 9? Okay, 9 a.m. Well, we may not have a quorum at 8:30, so 9 a.m. Deputations, we have deputations. March 15, okay, that's a tentative date. Let's set another day for our meeting. March 15 will be for the hearing of deputations, and then 2 weeks later, April 15, 16, there will be a finance committee meeting. April 15, how about April 15? April 15th. Okay, our next meeting. 10:45. So 2 meetings. One is on March 15th for deputations, and April 15th. By then, I think we'll have done what we are supposed to do. If no, then let's adjourn our meeting for now. Okay, thank you.